Get ready to turn your commute into a masterclass. This is the Study for the Bar in Your Car podcast.
That's right, the podcast where you can truly turn drive time into study time, making every mile a step closer to understanding complex legal concepts.
And we're your guides for this journey, Maude and Claude.
It's episode 12, and today we're diving deep into individual rights. This is really a cornerstone of American constitutional law, shaping our daily lives in pretty profound ways.
Absolutely. Now, for those of you tuning in for the first time, or maybe just wondering who we are.
Right, who are these voices?
Exactly. We should probably explain. We are AI bots, brought to life by the magic of artificial intelligence.
And more importantly, by an absolutely incredible resource, Angela's Constitutional Law Notes.
Yes. These are the detailed, really insightful notes of a dedicated law student, and they form the bedrock, really, of our discussions today.
Indeed. Angela is, well, she's the intellectual force behind this entire podcast endeavor. Her meticulous approach to legal studies is what allows us to distill such complex topics into, hopefully, an accessible format for you.
And for this particular episode on individual rights, we should mention Carol is assisting Angela, so ensuring the material is as thoroughly prepared and accurate as possible.
It's a great team effort, bringing these, let's face it, sometimes dense legal concepts to life.
Definitely. Now, if you find yourself with questions about the podcast, or maybe you just want to share some thoughts.
Or maybe catch a mistake we make.
Well, yes, that too. You can reach Angela directly. Her email is podcast@studyforthebarinyourcar.com.
podcast@studyforthebarinyourcar.com. It's a great way to connect.
And also for attorneys out there, or if you know a legal professional who could use an extra hand.
Angela also offers her services as a freelance law clerk. She's available for assistance with legal research, drafting motions, and other essential legal writing tasks.
Yep, and for those professional inquiries, you can reach her at hello@legalwriterandlawclerk.com.
hello@legalwriterandlawclerk.com.
Okay, so our mission today is to really demystify the constitutional protections that safeguard individual liberties.
We're going to navigate the, well, often complex landscape of rights, starting with the foundational principles, then specific amendments, the crucial state action requirement.
Oh, yeah. State action is huge.
It really is. And then the various levels of scrutiny that courts apply when they evaluate government actions.
Think of this as your essential roadmap to understanding how and when the Constitution steps in to protect you. We'll be pulling out the most important nuggets of knowledge from Angela's comprehensive law school notes.
Aiming for those aha moments that really solidify your understanding.
Exactly. So whether you're studying for the bar, prepping for a con law class, or just curious about the framework of American freedom, are you ready?
Let's get into it.
All right, let's dive right in.
Okay, so let's start by establishing the fundamental framework for how individual liberties are protected under the U.S. Constitution. This is a really crucial starting point, and it often catches people a bit off guard.
What's the core idea?
The core principle you absolutely have to grasp is this. With one very significant, very powerful exception, the U.S. Constitution primarily regulates government action, not private action.
That's such a critical distinction, isn't it? So if, say, my neighbor does something I think violates my rights, or a private company fires me unfairly.
Right. In most cases, the U.S. Constitution isn't directly involved in those private interactions. It's not designed to govern what your neighbor can say or what a private business's internal policies are. Its main focus is setting limits on what the government, federal, state, local, cannot do to its citizens. It's all about limiting governmental power.
Okay, but you mentioned a huge exception.
Yes, the monumental exception, and that is the 13th Amendment. This amendment directly and unequivocally bans slavery and involuntary servitude.
Okay, the ban on slavery.
But what makes it so unique, constitutionally speaking, is its enforcement power. The 13th Amendment permits Congress to regulate both private parties and government actors to enforce this ban.
So Congress can pass laws under the 13th Amendment that directly target private discrimination if it relates to slavery.
Exactly, or the badges and incidents of slavery, as the court has sometimes put it. This truly sets it apart from most other constitutional provisions, which typically require some form of state involvement, that state action we mentioned, to be applicable. It really reflects the profound historical context of its adoption after the Civil War.
Got it. And another key point you mentioned earlier is that states can actually give more rights than the federal Constitution, just not fewer.
Precisely. The U.S. Constitution sets a minimum floor for rights protection. States are absolutely free to expand upon those protections through their own state constitutions or laws. Many states do provide broader rights in certain areas.
Interesting. So how are we going to tackle all this? What's the plan?
We'll follow a logical path, mirroring the structure in Angela's fantastic notes. We'll start with the constitutional restrictions on power over individuals, looking at specific amendments.
Okay.
Then we'll dive deep into that essential concept of the state action requirement, who counts as the government.
All right. The gateway issue.
Exactly. And finally, we'll explore the various levels of scrutiny, rational basis, intermediate, strict, that courts use when they review government actions that potentially infringe on these rights.
Sounds like a solid plan. Let's start with those constitutional restrictions on power over individuals. First up, the Bill of Rights.
Okay, the Bill of Rights, the first 10 amendments. When these were originally drafted and ratified, their primary intent was actually quite specific.
What was that original intent?
To limit the power of the federal government only. Remember, the folks drafting the Constitution and the Bill of Rights were pretty wary of a powerful central authority. They wanted explicit prohibitions on its reach.
So thinking historically, that means like in 1795, a state government could have, say, established a state religion or maybe censored the press without violating the federal Bill of Rights.
That's basically right. It's a bit counterintuitive from our modern perspective, isn't it? But that was the original understanding. That began to change dramatically, though, with the ratification of the 14th Amendment after the Civil War.
Ah, the 14th Amendment. That's the game changer here.
Absolutely. Specifically, its due process clause. Over a long period of time, through a process the courts call incorporation, the Supreme Court has interpreted the 14th Amendment's due process clause to apply almost all the provisions of the Bill of Rights to the states as well.
So it wasn't like a switch flipped. It was gradual.
Very gradual, case by case, applying different rights against the states. It fundamentally reshaped the relationship between individual citizens and their state governments. It's truly one of the most significant transformations in American constitutional law.
Okay, now this is where it gets interesting, especially for anyone studying this. What didn't get incorporated? Are there parts of the Bill of Rights that still only apply to the federal government?
That's a great question, and yes, there are a couple of key exceptions that Angela's notes highlight, and these often pop up on exams.
Okay, what are they?
First, the Fifth Amendment's requirement of a grand jury indictment for serious criminal trials. States are not federally required by the Constitution to use grand juries to bring criminal charges, although many states do use them under their own state laws or constitutions.
So no federal constitutional right to a state grand jury indictment. What's the second one?
The second major exception is the Seventh Amendment's right to a jury trial in civil cases. While you generally have that right in federal court under the Seventh Amendment, the Supreme Court has held that this right is not incorporated against the states through the 14th Amendment. So states aren't constitutionally obligated to provide jury trials in all types of civil cases heard in state courts.
Those are definitely good ones to flag. Grand jury indictment and civil jury trial rights not incorporated against the states. Got it.
Exactly. Now, let's just circle back quickly to the 13th Amendment. We mentioned its unique scope, but it's worth just hammering that home.
Right. Banning slavery and involuntary servitude?
Its command is simple. Neither slavery nor involuntary servitude shall exist within the United States. But its power, again, lies in its unique application. Unlike most other constitutional provisions that need state action, the 13th Amendment lets Congress directly regulate both private parties and government actors to prevent slavery and, importantly, the badges and incidents of slavery.
So Congress has direct power, even over private individuals, if their actions are seen as perpetuating the effects of slavery.
That's the idea. It gives Congress a broad power to address systemic issues stemming from slavery, even in the private sphere. It's a testament to the absolute constitutional condemnation of slavery.
That direct application really underscores its significance. Okay, let's move to those other crucial post-Civil War amendments, the 14th and 15th.
Right, these are absolute cornerstones of individual rights protection today. The 14th Amendment, ratified in 1868, is incredibly broad. It has three key clauses that are just central to everything we're talking about. The Privileges, or Immunities Clause, the Due Process Clause, which we mentioned for incorporation, and the Equal Protection Clause.
Can you break those down quickly?
Sure. It declares that no state shall, notice, no state abridge the privileges or immunities of citizens of the United States, that's the P or I clause, nor shall any state deprive any person of life, liberty, or property without due process of law. that's due process, or deny to any person within its jurisdiction the equal protection of the laws. That's equal protection. It's all aimed at ensuring fundamental fairness and equality in how states treat people.
Okay, PRI, due process, equal protection, all directed at the states, and the 15th Amendment.
The 15th Amendment, ratified in 1870, zeroes in specifically on protecting the right to vote. It prohibits both the states and the federal government from denying or abridging a citizen's right to vote based on race, color, or previous condition of servitude.
So trying to secure the vote for formerly enslaved men, essentially.
That was the crucial goal, yes.
Oh.
Though, as history shows, enforcing that right was a long, long struggle involving poll taxes, literacy tests, and other discriminatory measures that weren't fully overcome for nearly a century.
Right. Okay, let's dive deeper into the 14th Amendment, specifically Section 5. Angela's notes really flag this as important, the scope and limitations of Congress's power under this enforcement clause.
Yes, Section 5. This is a really critical point for understanding the limits of federal power, especially Congress's power. Section 5 explicitly says Congress can enforce the provisions of the 14th Amendment, those clauses we just mentioned, through appropriate legislation.
So it sounds like Congress can pass laws to make sure states follow the 14th Amendment?
It does, but here's the crucial limitation the Supreme Court has placed on it. This power is remedial, not substantive.
Remedial, not substantive. What does that mean in practice?
It means Congress cannot use Section 5 to create new constitutional rights or to expand the scope of existing rights beyond what the 14th Amendment itself defines, as interpreted by the courts. Congress can only pass laws to remedy violations of rights that the Supreme Court has already recognized or is likely to recognize under the amendment.
Okay, so Congress can't just say, we think there should be a new fundamental right to X, so we're passing a law under Section 5. It has to be fixing a problem related to a right the courts already see in the 14th Amendment.
Exactly. Think of it like this. Congress can build a stronger fence around an existing right to stop violations, but it can't use Section 5 to unilaterally move the property lines and make the right bigger than the court says it is.
That's a helpful analogy. And there's another layer here, because Section 1 of the 14th Amendment applies only to state action.
Right. No state shall.
Congress's enforcement power under Section 5 is generally limited to regulating state governments, not federal actors or purely private parties, right?
That's generally the rule. A classic case that illustrates this is the civil rights cases from way back in 1883. Congress had passed the Civil Rights Act of 1875, which tried to outlaw racial discrimination by private businesses like hotels, theaters, and railroads.
Seems like a good idea.
But the Supreme Court struck down those parts of the act. The court said that under Section 5 of the 14th Amendment, Congress could only regulate state action, not private discrimination. Because the 14th Amendment itself only restricts states, the power to enforce it couldn't reach purely private conduct.
Wow, so that really established the boundary early on. Congress needed a different constitutional hook, like the Commerce Clause later, to regulate private discrimination in public accommodations.
Precisely. The 14th Amendment, Section 5, wasn't the tool for regulating private actors directly. Now, there's also this standard that Section 5 legislation must be proportionate and congruent. That sounds pretty specific. What's that about?
Yeah, that comes from City of Bourne v. Flores, right? A really important case from 1997.
It is. City of Bourne established this proportionality and congruence test. It means that for Congress's enforcement law under Section 5 to be valid, there needs to be a connection, a congruence between the injury to be prevented or remedied, the state constitutional violations, and the means adopted to that end, the federal law.
Okay, so the solution has to fit the problem.
Basically, yes. And it also has to be proportional. Congress needs to show a history and pattern of constitutional violations by the states that the law is designed to fix. And the remedy Congress provides must be tailored to address those specific violations without being overly broad or, again, creating new substantive rights.
Can you give an example? The Bourne case itself involved the Religious Freedom Restoration Act, or RFRA.
Right. In Bourne, Congress passed RFRA in response to a Supreme Court decision that Congress felt didn't adequately protect religious freedom. RFRA tried to impose a higher standard, strict scrutiny, on state laws that burdened religious exercise.
So Congress was trying to override the court's interpretation of the Free Exercise Clause.
Essentially, yes. And the Supreme Court struck down RFRA as applied to the states. The court said Congress hadn't shown a widespread pattern of unconstitutional state infringement on religious freedom that justified such a broad, sweeping federal law. RFRA wasn't seen as a proportionate remedy to actual state violations. Instead, it looked like Congress was trying to substantively redefine the scope of the free exercise right itself, which Section 5 doesn't allow.
So it was seen as an overreach, trying to define the right rather than just remedying violations of the existing right.
Exactly. It underscores that delicate balance between federal enforcement power and state autonomy, and ultimately the judiciary's role in interpreting the Constitution's scope.
What about using Section 5 to overcome state sovereign immunity? Can Congress let individuals sue states for damages if the state violates the 14th Amendment?
Yes, this is another key aspect of Section 5 power, but again, with limits. Congress can abrogate or override state sovereign immunity using its Section 5 power, allowing states to be sued directly by individuals for money damages.
Okay, so states aren't completely immune from lawsuits based on the 14th Amendment?
Not if Congress acts properly under Section 5.
Hmm.
But two conditions must be met. First, the law must clearly state Congress's intent to abrogate immunity. Second, the law must be a valid exercise of Section 5 power, meaning it targets state conduct that actually violates a substantive 14th Amendment provision, like due process or equal protection. And the remedy provided, like allowing lawsuits for damages, must be proportionate and congruent to that violation.
Is there a case that illustrates this?
Yes. A good example is Nevada Department of Human Resources via Hibbs. This case involved a provision of the Family and Medical Leave Act, FMLA, that allowed state employees to sue their states for damages if the state violated the FMLA's family care leave provisions.
And the court upheld this, allowing suits against the state.
Yes, the Supreme Court upheld it. The court reasoned that Congress had compiled sufficient evidence of a pattern of pervasive gender discrimination by states in administering leave benefits, essentially. States were applying leave policies in ways that stereotyped women as primary caregivers, violating the Equal Protection Clause. Therefore, allowing state employees to sue their states for damages under the FMLA was seen as a proportionate and congruent remedy to these documented constitutional violations by the states.
So, because there was evidence of states violating equal protection, Congress could authorize suits against the states as a remedy under Section 5.
Precisely. It's a critical mechanism for enforcing 14th Amendment rights against potentially unwilling states.
This is intricate stuff. It's not just about the rights themselves, but the complex interplay of congressional power, state sovereignty, and judicial interpretation.
Absolutely. Now, let's touch briefly on what Angela's notes call rights of national citizenship, particularly focusing on the privileges or immunities clause of the 14th Amendment we mentioned earlier.
Right, the PRI clause. It sounds really important. No state shall abridge the privileges or immunities of citizens of the United States. But my understanding is, historically, the Supreme Court basically neutered this clause right after it was ratified.
That's a very accurate, if blunt, assessment. You're likely thinking of the slaughterhouse cases from 1873. In that case, the Supreme Court interpreted the privileges or immunities clause of the 14th Amendment incredibly narrowly.
Oh, narrowly.
They said it only protected rights uniquely related to federal citizenship, things like the right to travel to the national capital, the right to petition Congress, the right to use navigable waters, protection on the high seas. It did not, according to the court in Slaughterhouse, protect the fundamental civil rights that states traditionally protected, like property rights or freedom of contract.
So it didn't incorporate the Bill of Rights against the states.
No, not through the PRI clause. That interpretation effectively gutted the clause for over a century. It meant that the Due Process Clause of the 14th Amendment became the primary vehicle for applying the Bill of Rights to the states, through that process of incorporation we discussed. The PRI clause largely lay dormant.
But didn't it make a comeback recently? Or at least wasn't there one significant modern case where the court relied on it? Something about the right to travel.
You're absolutely right. There is a key modern exception, Saenz v. Roe from 1999. This is the rare but important instance where the Supreme Court breathed some significant life back into the privileges or immunities clause.
What happened in Saenz?
California passed a law that limited welfare benefits for new residents during their first year in the state. They couldn't get California's higher benefit level. They were capped at the benefit level of the state they had just moved from.
Okay, so treating new residents differently just because they were new?
Exactly. And the Supreme Court struck down this law, relying explicitly on the privileges or immunities clause. The court held that the right to travel, which includes the right to migrate and resettle in a new state and be treated like other citizens of that state, is a fundamental aspect of national citizenship protected by the PRI clause. California's law created different classes of citizens based on how long they'd lived there, which unconstitutionally burdened this right to travel and resettlement.
So Saenz v. Roe is the key case to remember if you're thinking about the modern application of the Privileges or Immunities Clause, especially regarding the right to travel between states.
Absolutely. It's the standout example. While the clause remains narrowly interpreted overall, science shows it still has teeth, particularly concerning the right of citizens to move freely between states and be treated equally upon arrival.
Okay, fantastic. Now let's shift gears to what you called the gateway issue for so many constitutional claims, the state action requirement.
Yes, absolutely fundamental. This is often the very first question you have to ask when analyzing a potential constitutional rights violation under, say, the First Amendment, the 14th Amendment's due process or equal protection clauses. Is there state action?
And if the answer is no,
If there's no state action involved, then generally the Constitution simply doesn't apply to that conduct. The Constitution, remember, primarily restricts the government, not private individuals or entities.
so again, if it's just a private dispute, like a disagreement between neighbors or an issue with a private employer.
Generally, no constitutional claim
Mm.
based on those provisions. Now, identifying direct state action is usually pretty straightforward. Actions by the executive branch like police conduct,
Right.
legislative actions like laws passed by Congress or a state legislature,
Obvious.
or judicial actions like court rulings or enforcing judgments. Those are all clearly state action. This also extends to entities that are clearly arms of the government, like public schools funded and staffed by the state or state universities.
Okay, those are the easy ones. But the tricky part, and probably where bar exam questions like to live, is when private action gets treated as if it were state action. Angela's notes detail some exceptions, right? Limited, but crucial.
Exactly. These are the situations where the line blurs and a private actor's conduct can be attributed to the government for constitutional purposes. There are two main categories where this can happen. The first is the exclusive public functions exception.
And you emphasized exclusive earlier. This isn't just any function the public uses.
Absolutely critical word.
It's
Exclusive.
Yeah.
This category is extremely narrow. It applies only when a private party performs a function that has been traditionally and exclusively reserved to the government. The Supreme Court is very reluctant to expand this, recognizing that private entities do lots of things that benefit the public but aren't exclusively governmental.
So what are the classic examples?
The prime example is running an entire town. This comes from the case Marsh v. Alabama. In Marsh, a private corporation owned and operated a company town. It owned all the property, the streets, the sidewalks.
Like a private municipality?
Essentially, yes.
Yeah.
The Supreme Court found that by performing all the functions of a municipality, this private corporation was engaged in state action. Therefore, its attempt to prohibit someone from distributing religious literature on a sidewalk in the town violated the First and 14th Amendments.
That makes sense. If it looks like a town and acts like a town, it's treated like a town for constitutional purposes, even if privately owned. Angela's notes mention this came up on a 2013 essay exam. Still relevant.
Definitely still relevant. Another accepted example is conducting elections for public office. Even if a private political party runs a primary election, the court has held that this is a traditional public function and thus subject to constitutional constraints, particularly regarding racial discrimination.
Okay, so running a town, running elections, very limited list. What's the second major category where private action becomes state action?
This one's a bit broader, conceptually. Significant state involvement, sometimes called the entanglement exception. This is where the state is somehow significantly involved in or facilitating the private action.
This sounds more nuanced. How involved does the state have to be?
It requires more than just passive acquiescence. One clear example comes from the judicial enforcement of private agreements. The landmark case is Shelley v. Kramer.
Ah, the restrictive covenants case.
Exactly. In Shelley, private parties had entered into agreements, racially restrictive covenants, that prohibited selling or renting property to black individuals. The private agreement itself wasn't state action.
But
when the property owners went to state court to enforce these covenants, to get a court order stopping a sale to a black family, the Supreme Court said that the judicial enforcement was state action. The state court, by lending its power to enforce the discriminatory private contract, became implicated in the discrimination, violating the Equal Protection Clause.
So the state's judicial machinery was essential to making the private discrimination effective. That's a powerful concept.
It is. Another area involves situations where there's a sufficient entanglement or a symbiotic relationship between the government and the private actor. A key case here is Burton v. Wilmington Parking Authority.
What happened in Burton?
In Burton, a private restaurant that practiced racial discrimination leased space inside a publicly owned and operated parking garage. The state owned the building.
Okay, so leasing public property, is that enough?
Not just the lease itself. The court found state action because there was a symbiotic relationship. The state benefited financially from the restaurant's operations, like increased parking revenue, and the restaurant benefited from being in a public facility. They were mutually interdependent. This deep entanglement meant the state was effectively a joint participant in the restaurant's discrimination.
So mutual benefit, deep connection. But what about just getting a license from the state, like a liquor license? Does that entanglement the private actor? I'm thinking of Moose Lodge number 107 v. Irvis.
That's the perfect contrast case. In Moose Lodge, a private club that discriminated against black guests held a liquor license issued by the state of Pennsylvania.
Okay, so the state granted a license. State involvement.
The Supreme Court said no. This was not sufficient state action. This case highlights a crucial distinction. Merely granting a license, or providing basic government services like police and fire protection, or even providing some general funding, is typically not enough significant entanglement to tune private conduct into state action.
So what's the difference between Burton and Moose Lodge?
The level of interdependence and affirmative involvement. In Burton, the state and the restaurant were deeply intertwined financially and physically. In Moose Lodge, the liquor license was just general regulation. The state wasn't specifically authorizing, encouraging, or profiting from the club's discriminatory membership policies. The government must be affirmatively facilitating or benefiting from the specific unconstitutional conduct, not just interacting with the private entity in a general way.
Okay, so it's a much higher bar than just basic regulation or funding. The state needs to be almost a partner in the specific bad act.
That's a good way to put it. Finally, under this significant involvement category, there's a very specific bright-line rule regarding peremptory challenges in jury selection.
Peremptory challenges, those are where lawyers can strike potential jurors without giving a reason, right?
Correct. The Supreme Court has established a clear rule here. In cases like Georgia v. McCollum and Edmondson v. Leesville Concrete Co., the use of peremptory challenges by private litigants, whether it's the prosecution or defense in a criminal case or the plaintiff or defendant in a civil case, constitutes state action.
Even though it's private lawyers making the strikes, why is that state action?
Because jury selection is an integral part of the state-run judicial process. The judge, a state official, oversees it. The summonses are issued by the state. The entire framework is governmental. When private lawyers exercise peremptory challenges within that state-controlled system, particularly if they do so in a discriminatory way, like striking jurors based on race or gender, their actions are attributable to the state for equal protection purposes.
Okay. Because it happens within the formal machinery of the state court system, even the actions of private attorneys become state action in that specific context.
Exactly. It prevents the state from allowing private parties to inject unconstitutional discrimination into the heart of the judicial process.
Makes sense. So that state action requirement is definitely a critical first step. Once we've established that there is state action, how do courts actually review the government action that's being challenged? That brings us to the levels of scrutiny.
Right. This is where the court decides how closely to examine the government's justification for its law or action. It's not a one-size-fits-all analysis. The level of scrutiny applied depends heavily on the nature of the right being affected or the type of classification the government is making. There are three main levels, ranging from the most deferential to the most demanding.
Okay, let's start at the bottom. Rational basis review, sometimes called minimal scrutiny. This sounds like the easiest test for the government to pass.
It absolutely is. Under rational basis review, the law or government action is presumed to be constitutional. The burden of proof is entirely on the challenger, the person attacking the law, to prove that the law is not rationally related to any legitimate government interest.
Not rationally related to any legitimate interest. That sounds incredibly hard to prove.
It is. The challenger has to show the law is completely arbitrary or irrational. And the government doesn't even have to prove that the interest it claims was its actual reason for passing the law. As long as the government can come up with some conceivable legitimate purpose that the law could rationally serve, even if thought up after the fact, the law will likely be upheld.
So the government almost always wins under rational basis.
Almost always. The deference to the government is enormous. This standard typically applies to laws involving economic regulation, social welfare, or classifications that are not considered suspect or quasi-suspect.
What are some examples of classifications that get rational basis review?
Things like age classifications, like mandatory retirement ages, disability classifications, wealth classifications, laws affecting the poor, or regulations concerning business activities, contracts, public assistance payments, or inheritance rights. Most ordinary social and economic legislation falls under this lenient standard.
And Angela's notes specifically mention abortion regulations now fall under this standard too.
Yes, that's a major recent development. Following the Supreme Court's decision in Dobbs v. Jackson Women's Health Organization in 2022, which overruled Roe v. Wade and Planned Parenthood v. Casey, the court held that there is no longer a fundamental constitutional right to abortion. As a result, government laws regulating or restricting abortion are now subject only to rational basis review.
Wow. So that shifts abortion regulations from needing to survive strict scrutiny, as under Roe, down to the most deferential standard, making it much easier for states to regulate or ban abortion.
Precisely. It's a fundamental change in the legal landscape surrounding abortion.
Okay, so that's rational basis, very deferential. What's the next step up? Intermediate scrutiny.
Intermediate scrutiny requires more from the government. Under this test, the government must show that the challenged law or classification is substantially related to an important government interest.
Okay, substantially related and important interest. That sounds tougher than rationally related and legitimate interest. And who has the burden of proof here?
Crucially, the burden of proof shifts to the government. The government has to justify its law, providing evidence that the classification truly serves an important objective and that the means chosen are substantially connected to achieving that objective. It's no longer presumed constitutional.
And what kinds of classifications typically trigger intermediate scrutiny?
This level primarily applies to classifications based on gender, sex, and illegitimacy, classifications based on whether a child's parents were married.
Gender classifications get intermediate scrutiny. Can you give an example?
The classic case is Craig v. Boren. Oklahoma had a law allowing females to buy 3.2% beer at age 18, but males had to wait until age 21.
Okay, different drinking ages based on sex.
Right. The state argued this was justified by traffic safety concerns, claiming young men were more likely to drink and drive. The Supreme Court applied intermediate scrutiny. It found that while traffic safety was an important government interest, the statistics provided by Oklahoma didn't show that the gender-based distinction was substantially related to achieving that interest. The connection was too weak, too based on stereotypes. So the law was struck down.
So intermediate scrutiny provides meaningful review, but doesn't automatically condemn the law like the next level might.
Exactly. It's a middle ground. Some laws survive, some don't. It requires a closer look at the government's justifications and the fit between the means and the end.
All right, now for the highest level, the toughest test. Strict scrutiny, also called maximum scrutiny.
This is the most demanding standard in constitutional law. If a law triggers strict scrutiny, it is presumed unconstitutional, and the government faces an incredibly heavy burden to save it.
What exactly does the government have to prove?
The government must prove that the law is narrowly tailored to achieve a compelling government interest. And not only that, it must also typically show that the law is the least restrictive means available to achieve that interest.
Compelling interest, narrowly tailored, least restrictive means. That sounds almost impossible to meet.
It's often described as strict in theory, fatal in fact. While not literally always fatal, laws reviewed under strict scrutiny very rarely survive. The burden of proof is squarely on the government.
Okay, so what triggers this incredibly high level of review? Angela's notes mention two main categories: suspect classifications and fundamental rights.
All right. First, suspect classifications. These are classifications based on traits that have historically been subject to discrimination, are often immutable, and where the group lacks political power. The classic examples are classifications based on race, national origin, and usually alienage, legal status as a non-citizen.
So any law that treats people differently based on their race or national origin is automatically subject to strict scrutiny.
Yes. Think of laws requiring racial segregation or affirmative action programs that use race as a factor. Those trigger strict scrutiny. Alienage classifications made by states are also usually suspect unless the classification relates to participation in the state's political process or core governmental functions.
What do you mean by that exception for alienage?
States can generally require U.S. citizenship for things like voting, holding elective office, or serving as police officers or public school teachers. These roles are seen as closely tied to the process of self-governance, so classifications limiting them to citizens are typically reviewed under the much more lenient rational basis standard, not strict scrutiny. It's called the political function exception.
Okay, that's an important nuance for alienage. Now, the second category triggering strict scrutiny, fundamental rights.
Yes. If a government action significantly burdens a right considered fundamental under the Constitution, that action gets strict scrutiny regardless of the classification involved.
And how do we know what rights are fundamental? Angela's notes say they are rights, quote, deeply rooted in our nation's history and tradition and essential to the concept of ordered liberty. That sounds interpretive.
It is definitely interpretive. Fundamental rights can be either enumerated, explicitly listed in the Constitution, like the right to free speech in the First Amendment, or unenumerated rights that are not explicitly listed but are considered implicit in the Constitution's structure, history, or other provisions,
Yeah.
often derived from the liberty protected by the due process clauses of the Fifth and 14th Amendments.
So the court has to decide if an unenumerated right is deeply rooted enough to be fundamental. That seems like a place where judicial philosophy really matters.
Absolutely. Identifying unenumerated fundamental rights is one of the most debated areas of constitutional law. But once a right is deemed fundamental, any significant government infringement gets strict scrutiny.
Okay, let's walk through some of the key fundamental rights that trigger strict scrutiny based on Angela's outline. First, the right to vote.
The right to vote is considered fundamental because it's preservative of all other rights in a democracy. Any law that places a substantial burden on the ability of citizens to vote is subject to strict scrutiny.
What kind of laws would that include?
Things like significant voter registration requirements, laws affecting ballot access for candidates or parties, poll taxes, which are explicitly banned by the 24th Amendment for federal elections and unconstitutional for state elections, or apportionment schemes that dilute voting power. For example, while challenges to purely partisan gerrymandering have been deemed non-justiciable political questions by the Supreme Court in Rucho v. Common Cause, meaning federal courts won't hear them.
Right, the courts stay out of fights over purely political map drawing.
Challenges based on malapportionment, where districts have significantly unequal populations, violating the one-person, one-vote principle derived from the Equal Protection Clause, are justiciable and are reviewed under strict scrutiny, thanks to landmark cases like Baker v. Carr and Reynolds v. Sims. So, laws affecting the weight or fairness of a vote often trigger strict scrutiny.
Okay, voting is fundamental. Next, free speech. First Amendment stuff, this is huge.
Absolutely massive. Free speech, protected by the First Amendment and applied to the states through the 14th, is a cornerstone fundamental right. Content-based restrictions on speech laws that regulate speech because of its message or viewpoint are subject to strict scrutiny.
And it's not just the right to speak, right? It's also the right not to speak.
That's a critical aspect. The freedom of speech includes the freedom not to be compelled by the government to express a message you disagree with. The classic case is West Virginia State Board of Education v. Barnett, where the Supreme Court held that public schools could not force students to salute the flag and recite the Pledge of Allegiance if it violated their conscience. Compelled speech is a serious First Amendment violation.
But this doesn't apply to government speech itself, right? Like a state motto on a license plate.
Correct. When the government itself is speaking, it can generally express its own viewpoint. The compelled speech doctrine applies when the government tries to force private individuals or groups to adopt or promote the government's message.
What about laws that are too vague? How does that relate to free speech?
Laws regulating speech must be clear enough so that ordinary people can understand what conduct is prohibited. If a law is too vague, it violates due process and the First Amendment under the void for vagueness doctrine.
Why is vagueness bad for free speech?
Two main reasons. First, it doesn't give people fair notice of what's illegal. Second, and perhaps more importantly for free speech, vague laws give too much discretion to law enforcement officials, like police officers or prosecutors, creating a risk that the law will be enforced arbitrarily or used to target unpopular speech or speakers. A vague law can have a chilling effect, causing people to self-censor and avoid potentially protected speech for fear of violating the unclear law.
Can you give an example of a law struck down for vagueness?
Sure. In Coates v. City of Cincinnati, the court struck down an ordinance that made it illegal for 3 or more people to assemble on a sidewalk and conduct themselves in a manner annoying to passersby. The word annoying was found to be inherently subjective and vague, failing to specify what conduct was forbidden.
Okay, so laws need clarity. What about giving officials unfettered discretion to grant permits for speech, like protests or parades?
That's also unconstitutional. Licensing schemes or permit requirements for speech activities, like using a public park, must have clear, objective, and definite standards for the licensing official to follow. If the official has unfettered discretion, meaning they can grant or deny a permit based on their own subjective judgment, the scheme is invalid on its face.
Why is unfettered discretion so bad?
Because it creates an unacceptable risk of viewpoint discrimination. An official with unlimited discretion could easily deny permits to groups whose messages they dislike while granting them to favored groups. The standards must be neutral and limited.
And related to that, what about prior restraints? That sounds like censorship before speech even happens.
Prior restraints. Government actions that prevent speech from occurring before it happens, like getting an injunction against publication or requiring pre-publication approval, are the most serious and least tolerable infringement on First Amendment rights. They carry an extremely heavy presumption against their constitutional validity.
So the government almost never wins when trying to impose a prior restraint, even for national security. I'm thinking of the Pentagon Papers case, New York Times Company, United States.
That's the quintessential example. In the Pentagon Papers case, the Nixon administration tried to stop the New York Times and Washington Post from publishing classified documents about the Vietnam War, claiming it was necessary for national security.
And the Supreme Court said?
The Supreme Court refused to issue the injunctions, allowing publication. The court emphasized the heavy presumption against prior restraints, while not ruling out the possibility entirely in truly extraordinary circumstances. The government failed to meet the incredibly high burden of proving that publication would inevitably, directly, and immediately cause grave harm to national security interests. The bar is set extremely high.
Are there any exceptions where prior restraints might be allowed?
Very few. Some narrowly drawn permit requirements for parades or protests focused only on time, place, and manner aspects and containing clear standards might be permissible. But generally, the government must punish illegal speech after it occurs, not prevent it beforehand.
Okay, now what about speech that isn't protected by the First Amendment? Obscenity comes to mind.
Right. Obscenity is one of the very few categories of speech that receives no First Amendment protection. But the definition of obscenity is very specific, established by the Supreme Court in Miller v. California. It's a three-part test, and all three parts must be met.
Okay, what's the Miller test?
First, the average person, applying contemporary community standards, must find that the work, taken as a whole, appeals to the prurient interest. Prurient basically means a shameful or morbid interest in sex.
Okay, appeals to prurient interest using community standards. What's part two?
Second, the work must depict or describe, in a patently offensive way, sexual conduct specifically defined by the applicable state law. This part also uses contemporary community standards to judge offensiveness, but the state law itself has to clearly define what kind of sexual conduct is prohibited.
So community standards for prurience and offensiveness, but the state law must define the prohibited conduct. Got it, part three.
Third, the work, taken as a whole, must lack serious literary, artistic, political, or scientific value. This is often called the SLAPS test. And crucially, this third prong is judged by a national standard, not local community standards.
Ah, that's a key distinction. Community standards for the first two parts, prurience, offensiveness, but a national standard for the third part, serious value. That seems designed to protect works that might offend some communities but have recognized merit nationally.
Exactly. It prevents truly valuable works from being banned just because they might be unpopular or offensive in a particular locality. So a work has to fail all three parts of the Miller test: appeal to prurient interest, community standard; be patently offensive under state law, community standard; and D, lack serious value, national standard, to be considered unprotected obscenity.
That's a high bar for the government to meet to ban something as obscene. Okay, another fundamental right, the right to interstate travel.
Yes, the right to travel from state to state is a fundamental right, protected by several parts of the Constitution, including, as we saw in Saenz v. Roe, the Privileges or Immunities Clause. Any law that significantly burdens this right to migrate and resettle between states will trigger strict scrutiny.
So like a state law imposing a hefty fee just to move into the state, or denying new residents essential benefits for a long period.
Exactly. Those kinds of laws that penalize or deter people from moving between states would face strict scrutiny. However, it's important to distinguish this from travel within a state.
Oh, travel within a state isn't fundamental.
Generally, no. The right to interstate travel is not considered a fundamental right triggering strict scrutiny. Regulations affecting travel solely within a state's borders, like local traffic laws or residency requirements for certain local benefits, as long as they don't penalize recent interstate travel, usually only need to pass rational basis review.
Good distinction. Interstate travel equals fundamental. Interstate travel, generally not. Okay, finally, Angela's notes group together several privacy-related rights, many of which are unenumerated.
Yes, this cluster includes rights related to personal, autonomy, family, and intimate decisions. These are often derived from the liberty component of the Due Process Clause. They include the fundamental right to marry. This was extended to same-sex couples in Obergefell v. Hodges. The right of married persons to use contraceptives, established back in Griswold v. Connecticut. The court later extended this right to unmarried individuals as well in Eisenstadt v. Baird.
Okay, contraception.
The right of adults to engage in private, consensual, non-commercial sexual activity. This was recognized in Lawrence v. Texas, which struck down state laws criminalizing same-sex sodomy.
In Lawrence v. Texas, important case.
The right of parents to make decisions regarding the care, custody, and control of their children. This includes decisions about education, upbringing, and medical care.
Parental rights.
And the right of related persons to live together in a single household, protecting family living arrangements from certain types of zoning or other restrictions.
So a range of personal, intimate, and family-related decisions get this high level of protection. What about the right to refuse medical treatment? That seems intensely personal, too.
It is. The Supreme Court recognized in Cruzan v. Director, Missouri Department of Health, that competent adults have a constitutionally protected liberty interest in refusing unwanted medical treatment, even life-sustaining treatment like hydration and nutrition.
So that's a fundamental right. Does it get strict scrutiny?
The court in Cruzan recognized the liberty interest, but didn't explicitly label it fundamental or specify the exact level of scrutiny. It did allow states to require clear and convincing evidence of the patient's wishes before terminating life support for an incompetent patient, suggesting the state's interest in preserving life is significant. Similarly, the court in Lawrence v. Texas, while striking down the sodomy law, didn't explicitly state the level of scrutiny it was applying to consensual adult sexual activity.
So sometimes the court recognizes a right as constitutionally protected liberty, but leaves the exact level of scrutiny somewhat ambiguous.
Yes, that can happen. It highlights that while a right might be protected, the precise legal test applied to government infringements isn't always definitively settled immediately, leaving room for future clarification or debate.
That really shows how constitutional law evolves. Okay, this discussion of rights and scrutiny is essential, but what about getting a case into federal court in the first place? Let's shift to the justiciability doctrines and federal court jurisdiction. These are like the gatekeepers, right?
Absolutely critical gatekeepers. These doctrines determine whether a federal court even has the power under Article 3 of the Constitution to hear a case at all. Article 3 limits federal judicial power to actual cases and controversies.
Cases and controversies, what does that mean practically?
It means federal courts can only decide real, live disputes between adverse parties. They can't issue opinions on hypothetical questions, resolve political disagreements that aren't legal disputes, or give advice. If a case doesn't meet this case or controversy requirement, it's deemed non-justiciable, and the court must dismiss it. It ensures the courts stick to their judicial role and don't wade into abstract or purely political matters.
So no, just asking the court, what if?
Exactly. Yeah. Which leads directly to the first justiciability doctrine, advisory opinions. Federal courts cannot issue them. They won't give opinions on the constitutionality of proposed legislation or answer abstract legal questions divorced from a specific factual dispute between actual parties with opposing interests.
Okay, no advisory opinions. Next, standing. This sounds like you have to be the right person to bring the lawsuit.
That's precisely it. Standing asks, is this the proper party to bring this matter before the court for adjudication? To have standing, a plaintiff must personally demonstrate three essential elements.
What's the first element?
Injury, in fact. This is the big one. The plaintiff must show they have suffered or will imminently suffer a direct and personal injury. It has to be concrete and particularized, meaning it affects the plaintiff in a personal and individual way, not just as a member of the general public.
Does the injury have to be economic? What if it's like a violation of free speech rights?
No, it doesn't have to be economic. While the injury must be concrete, the Supreme Court has recognized that intangible injuries, like the violation of constitutional rights, free speech, voting rights, privacy, or even reputational harm, can qualify as concrete injuries for standing purposes, as clarified in Spokio v. Robbins. However, Spokio also warned that just alleging a bare procedural violation of a statute without any actual harm isn't enough for a concrete injury.
What about taxpayer standing? Can I sue just because I'm a taxpayer and I don't like how the government is spending my money or because I think a law violates the Constitution?
Generally, no. The Supreme Court has consistently held that simply being a taxpayer and disagreeing with a government expenditure doesn't create a sufficiently direct and particularized injury for standing. Your interest is seen as too remote and shared with all other taxpayers.
But isn't there a narrow exception related to the Establishment Clause?
Yes, there is one very narrow exception established in Flast v. Cohen. A taxpayer does have standing to challenge a specific congressional spending measure, an expenditure under the Taxing and Spending Clause, if they allege it violates the Establishment Clause, the clause prohibiting government establishment of religion. For example, challenging a federal law that directly funds religious schools. But this exception is very limited. It generally doesn't apply to challenges to tax credits, general discretionary executive spending, or property transfers. So most taxpayer suits fail for lack of standing.
Okay, injury in fact is the first hurdle. What are the other two elements of standing?
Second, causation. The plaintiff's injury must be fairly traceable to the challenged conduct of the defendant. There has to be a causal link. The injury can be the result of the independent action of some third party, not before the court.
Makes sense. The defendant has to have caused the harm. And the third?
Third, redressability. It must be likely, not merely speculative, that a favorable court decision will actually remedy the plaintiff's injury. If winning the lawsuit wouldn't actually fix the problem for the plaintiff, then the court's opinion would be essentially advisory, which Article 3 forbids.
Injury, causation, redressability, all required for standing. What about suing on behalf of someone else? Third-party standing, is that allowed?
The general rule is no. Plaintiffs must assert their own rights and injuries. But there are limited exceptions where a plaintiff can assert the rights of a third party.
What are those exceptions?
One is if there's a close relationship between the plaintiff and the third party, and the plaintiff is a suitable advocate for the third party's rights. Think of a doctor asserting the rights of their patients in challenging abortion restrictions, or sometimes vendors asserting the rights of their customers, like the bartender in Craig v. Boren asserting the rights of his young male customers.
Okay, a close relationship. What's another exception?
Another is if the injured third party is unlikely to be able to assert their own rights. This often applies when the third parties face significant obstacles or burdens in bringing the lawsuit themselves, perhaps due to privacy concerns or fear of reprisal. The classic example is NAACP v. Alabama, where the NAACP was allowed to assert its members' First Amendment associational rights to protect their anonymity, as forcing the members themselves to sue would defeat the purpose of that anonymity.
So sometimes it's allowed out of necessity to ensure rights can be vindicated. What about generalized grievances? You mentioned this under injury, in fact.
Right. This is closely related to injury, in fact, but also stands as a separate prudential barrier. Federal courts will not adjudicate claims where the plaintiff's alleged injury is widely shared by the public at large and is essentially a complaint about government policy or conduct rather than a specific individualized harm. You can't sue solely as a citizen or taxpayer claiming the government isn't following the law properly. The injury has to be distinct to you or a defined group, not just a general complaint about governance.
Okay, that clarifies standing. Let's move to ripeness. This is about timing, right?
Yeah.
Is the case ready to be heard? Not too early.
Exactly. Ripeness determines whether a dispute has matured sufficiently to warrant judicial intervention, particularly in cases seeking pre-enforcement review of a statute or regulation, challenging a law before it's actually enforced against you. A case isn't ripe if it relies on uncertain or contingent future events that might not occur.
So how does a court decide if a case is ripe for pre-enforcement review?
The leading test comes from Abbott Laboratories v. Gardner. It involves balancing two factors. One, the hardship the plaintiff would suffer without pre-enforcement review. Is the plaintiff facing an immediate dilemma, like having to choose between complying with a costly regulation or risking prosecution? The greater the hardship, the more likely the case is ripe. Two, the fitness of the issues for judicial decision. Are the issues primarily legal rather than factual? Would further factual development make the legal issues clearer? If the issues are purely legal and the record is developed, the case is more likely fit for review.
So, hardship to the plaintiff and fitness of the legal issues. That determines ripeness. What about the opposite timing problem? Mootness. When a case becomes too late.
Right. Mootness occurs if events after the lawsuit has been filed effectively resolve the plaintiff's injury or dispute. If the controversy ceases to exist, the case becomes moot because there's no longer a live case or controversy for the federal court to decide under Article 3. The court can't give an opinion on a resolved issue.
So if the challenge law is repealed or the plaintiff gets the relief they wanted through other means, the case might become moot.
Exactly. A live controversy must persist throughout all stages of the litigation, including appeal.
But surely there are exceptions. Otherwise, couldn't defendants just stop their bad behavior temporarily to get a case dismissed? Or issues that resolve quickly might never get reviewed?
Yes, there are crucial exceptions to the mootness doctrine. First, wrongs capable of repetition, yet evading review. This applies to situations where the injury is inherently short-lived, like pregnancy in an abortion challenge or a short-term government order, such that it will always expire before the case can be fully litigated, and there's a reasonable expectation that the same complaining party could be subjected to the same action again.
Okay, that makes sense for issues that are over quickly. What else?
Second, voluntary cessation by the defendant. If the defendant voluntarily stops the allegedly illegal conduct after the lawsuit starts, the case generally isn't moot unless the defendant can prove there's no reasonable chance they could resume the behavior. This prevents defendants from manipulating the system just to avoid a ruling.
Good. Protects against strategic mooting. Any others?
Third, class actions. If the named plaintiff's individual claim in a class action becomes moot, maybe they graduate or their specific issue is resolved, the class action itself generally does not become moot as long as the claims of other unnamed class members remain live. The class acquires a legal status separate from the named plaintiff.
Okay, those exceptions keep important cases alive. Finally, under justiciability, the political question doctrine. This sounds like the court's just saying, nope, not our job.
That's a pretty good summary. The political question doctrine identifies certain issues that are constitutionally committed to another branch of government, Congress or the president, or are simply beyond the competence or appropriateness of judicial resolution. These issues are deemed non-justiciable, meaning federal courts will not decide them, even if all the other justiciability requirements like standing and ripeness are met.
Why would courts refuse to decide certain issues? Isn't their job to interpret the law?
It is, but the political question doctrine recognizes that the Constitution itself assigns certain decisions exclusively to the political branches, or that some issues lack judicially discoverable and manageable standards for resolution. It's about respecting the separation of powers and avoiding judicial entanglement in inherently political disputes where the courts lack the tools or authority to provide a meaningful resolution.
What are some classic examples of non-justiciable political questions?
Challenges relating to the conduct of foreign policy are often deemed political questions, for instance. Cases challenging the president's decision to recognize a foreign government, or how a war is being conducted, or the process for treaty withdrawal. Challenges to the impeachment and removal process are also non-justiciable, as the Constitution gives the House and Senate specific roles here. Nixon v. United States, the judge, not the president. Challenges to the Guarantee Clause of Article 4, ensuring each state a Republican form of government, are considered political questions. And, as we mentioned, challenges to partisan gerrymandering were recently declared non-justiciable political questions for federal courts in Rucho v. Common Cause.
But didn't you say challenges to malapportionment, unequal district populations are justiciable, thanks to Baker v. Carr?
Exactly. That's the critical distinction. While partisan gerrymandering, drawing lines for political advantage, is considered a political question due to lack of manageable judicial standards, challenges based on malapportionment, unequal populations violating one person, one vote, under the Equal Protection Clause are justiciable. Baker v. Carr famously held that equal protection challenges to legislative apportionment are not political questions, because the courts do have manageable standards, the principle of population equality, to apply.
So the type of challenge matters hugely in the gerrymandering context. Political advantage, political question. Unequal population, justiciable, equal protection claim.
You've got it. That's a key takeaway.
Okay, so assuming a case clears all these justiciability hurdles, standing, ripeness, not moot, not a political question, how does it actually get to the Supreme Court for review?
The vast majority of cases reach the Supreme Court through a writ of certiorari. This is basically an order from the Supreme Court to a lower court, usually a federal court of appeals or a state Supreme Court, to send up the record of the case for review.
And the court grants certiorari in every case where it's requested.
Oh, absolutely not. Getting certiorari granted is very difficult. The court receives thousands of petitions each year and grants review in only a small fraction, maybe 70, 80 cases. It takes the affirmative vote of 4 justices to grant certiorari. This is known as the Rule of 4.
The rule of four. So four justices think the case is important enough to hear, and the court has almost complete discretion in deciding which cases to take.
Almost complete discretion, yes. They tend to select cases involving important federal questions, especially where there are conflicting decisions among the lower federal courts of appeals or between federal courts and state supreme courts, or cases involving significant constitutional issues that need clarification.
Are there any cases the Supreme Court has to hear where review isn't discretionary?
There used to be more mandatory appeals, but Congress has largely eliminated them. Today, the main category involves limited appeals from decisions of special three-judge federal district courts. These special courts are convened only for certain specific types of cases, like challenges to the constitutionality of congressional or state legislative apportionment. By statute, decisions of these three-judge courts can sometimes be appealed directly to the Supreme Court, and in those limited instances, the court's review is technically obligatory, not discretionary certiorari. These are very rare compared to the certiorari path.
So, for practical purposes, getting Supreme Court review almost always means convincing at least four justices to grant that discretionary writ of certiorari.
That's the reality.
Okay, this whole discussion really highlights the intricate structure of the judiciary. Now, let's broaden our view again and touch upon the overarching constitutional structures that frame all of this. Federalism and separation of powers. Angela's notes have some key points here, too.
Yes, these are the foundational architectural principles of the U.S. constitutional system. Federalism deals with the vertical division of power between the national government and the state governments. Separation of powers deals with the horizontal division of power among the three branches of the federal government: legislative, Congress, executive president, and judicial courts. Both are designed to prevent the concentration of power and protect liberty.
Let's start with a core federalism concept: police power. How does that differ between states and the federal government?
States possess broad inherent police powers. This is the general authority of state governments to enact laws and regulations to protect the health, safety, welfare, and morals of their citizens. It's incredibly broad, covering everything from criminal law and traffic regulations to zoning, public health, and family law. The main limits are that state police power actions must be reasonable and not violate the Constitution or federal laws.
Okay, states have broad police power. What about the federal government? Does it have a general police power?
No, this is a crucial distinction in federalism. The federal government generally does not have a general police power. Its powers are limited to those specifically enumerated in the Constitution, like regulating commerce, taxing, spending, declaring war, plus those implied powers necessary and proper to carry out the enumerated ones.
So the federal government can't just pass a law for the general welfare unless it connects to an enumerated power.
Correct. The only exceptions where the federal government does exercise something akin to police power are in areas of exclusive federal jurisdiction, like Washington, D.C., federal territories, military bases, or Indian reservations. But nationwide, federal laws need a constitutional hook, like the Commerce Clause or the spending power.
This sometimes leads to clashes, right? Where the federal government tries to regulate something that seems like a local issue. Angela's notes mention Bond v. United States as an interesting example.
Bond is a fascinating case that really illustrates this federalism tension. It involved a woman who used toxic chemicals to try and injure her husband's mistress. A purely local dispute, really, like a domestic assault.
Okay, sounds like a state crime.
You'd think so.
Uh-huh.
But federal prosecutors charged her under a federal statute that was designed to implement an international chemical weapons treaty.
Wow. Using an international chemical weapons law for a local assault?
Exactly. The Supreme Court ultimately expressed serious concerns about this application. While the court decided the case on statutory interpretation grounds, saying Congress likely didn't intend the treaty implementing statute to cover such ordinary local crimes, the underlying issue was federalism. The court strongly suggested that stretching federal power, especially power derived from treaties, to cover purely local criminal matters traditionally handled by state police powers would raise grave constitutional questions and potentially violate the 10th Amendment's reservation of powers to the states. It's a reminder that federal power, even treaty power, has limits grounded in federalism.
A very potent reminder. Okay, let's move specifically to congressional powers under Article 1. We know they're enumerated, but also implied through the necessary and proper clause.
Right. Article 1, Section 8 lists Congress's specific powers: commerce, taxing, spending, war, etc. Then comes the necessary and proper clause, often called the elastic clause.
Why elastic?
Because it gives Congress flexibility. It says Congress can make all laws which shall be necessary and proper for carrying into execution the foregoing powers. It stretches Congress's ability to implement its listed powers.
How has necessary and proper been interpreted? Does it mean absolutely essential?
No, the landmark case McCulloch v. Maryland established early on that necessary doesn't mean absolutely indispensable. Chief Justice Marshall interpreted it broadly to mean anything convenient, useful, or conducive to achieving a legitimate congressional end connected to an enumerated power.
But then this seems crucial. It's not an independent source of power, right? It has to be linked to something else in Article 1, Section 8.
Absolutely critical point. You nailed it. The necessary and proper clause grants no power on its own. It only allows Congress to choose the means to effectively carry out its other enumerated powers. So Congress can do what's necessary and proper to regulate interstate commerce, or necessary and proper to raise an army, or necessary and proper to establish post offices. It must always be tethered to an enumerated power.
Okay. What about Congress's taxing and spending power? That seems incredibly broad, too. Congress shall have power to lay and collect taxes to provide for the general welfare of the United States.
It is an extremely broad power. Congress can tax and spend for virtually any purpose that it believes serves the general welfare. The courts give huge deference to Congress's judgment about what constitutes the general welfare. This power allows Congress to fund programs and influence policy in areas it might not be able to regulate directly.
Didn't the Affordable Care Act, ACA individual mandate survive based on this power?
Yes, in the major case National Federation of Independent Business v. Sebelius, NFIB, the Supreme Court rejected the argument that the individual mandate requiring people to buy health insurance or pay a penalty was a valid exercise of the Commerce Clause power. However, a majority of the court upheld the mandate as a constitutional exercise of Congress's power to tax. The court reasoned that the penalty for not having insurance functioned like a tax and was within Congress's broad authority under the Taxing and Spending Clause.
So the taxing power saved it. What about the Commerce Clause power itself? Article 1, Section 8, Clause 3. This one has been hugely important and controversial throughout history.
Hugely. The Commerce Clause gives Congress the power to regulate commerce among the several states. The Supreme Court has interpreted this to allow Congress to regulate three broad categories of activity.
What are those three categories?
1. Congress can regulate the channels of interstate commerce. These are the pathways commerce uses: highways, waterways, airways, railroads, even the internet. Congress can keep them clear, regulate their use.
Okay, channels. What's 2?
2. Congress can regulate the instrumentalities of interstate commerce, or persons or things in interstate commerce. This means regulating things like trucks, trains, airplanes, ships, goods being shipped, and even the people operating these instrumentalities: pilots, truck drivers.
Channels, instrumentalities. And the third one, this is the big one, right?
3. Congress can regulate activities that have a substantial effect on interstate commerce. This is the broadest category and the source of most Commerce Clause litigation. Even purely local activities can be regulated under this prong if they, in aggregate, have a substantial effect on interstate commerce.
The aggregation principle, like in Wickard v. Filburn, the farmer growing wheat for his own use.
Exactly. Wickard is the classic example. A farmer grew wheat purely for consumption on his own farm, exceeding federal quotas. The court said even this purely local, non-commercial activity could be regulated because if many farmers did the same thing, the aggregate effect would substantially impact the national wheat market, interstate commerce.
But the court has put some limits on this substantial effects test, especially for non-economic activity, right? I'm thinking United States v. Lopez.
Yes. Lopez, 1995, marked a significant shift, or at least a clarification. The court struck down the Federal Gun-Free School Zones Act, which banned possessing a gun near a school. The court held that possessing a gun in a local school zone was a non-economic activity. And for non-economic interstate activity, the court said aggregation to find a substantial effect on interstate commerce is generally not permissible. The link between guns near schools and interstate commerce was just too tenuous, too indirect.
So there's a distinction. If the local activity being regulated is economic in nature, like growing wheat, even for home use, aggregation is allowed under Wickard. If it's non-economic, like possessing a gun near a school, aggregation generally isn't allowed under Lopez unless it's part of a larger regulation of economic activity.
That's the key distinction the court drew. It signaled that the Commerce Clause power, while broad, is not unlimited, especially when Congress tries to regulate areas traditionally handled by states, like crime or education, using a commercial justification.
This ties into the 10th Amendment and the anti-commandeering doctrine, protecting state sovereignty.
Exactly. The 10th Amendment reserves powers not delegated to the federal government to the states or the people. Flowing from this, the anti-commandeering doctrine says Congress generally cannot commandeer state governments, meaning it can't directly compel state legislatures to enact specific laws or state executive officials to enforce federal laws.
So Congress can't just order states around.
Not directly as governments. Landmark cases like New York v. United States, Congress couldn't force states to take ownership of nuclear waste, and Prince v. United States, Congress couldn't compel state police officers to conduct federal background checks for gun purchases, established this principle. The federal government can regulate people directly, but it can't conscript state governments into administering federal programs.
But Congress can persuade states, right? Using money. The strings on grants approach.
Yes, that's the big workaround, or rather a permissible use of a different power. Spending power. While Congress can't directly command states, it can attach conditions to federal funds it gives to the states. If states want the federal money, they have to comply with the conditions.
Like the drinking age case, South Dakota v. Dole.
Precisely. In Dole, Congress threatened to withhold a small percentage, 5%, of federal highway funds from states that didn't raise their drinking age to 21. The Supreme Court upheld this. It said the condition was clearly stated, related to the purpose of the highway funds, safe travel, and crucially was not unduly coercive. Losing 5% of highway funds was pressure, but it still left South Dakota with a legitimate choice.
But wasn't the Medicaid expansion in the ACA found to be unduly coercive? Back to NFIB v. Sebelius again?
Yes, that's the case that set the outer limit. The ACA originally threatened states with the loss of all their existing federal Medicaid funding, often billions of dollars, a huge chunk of state budgets, if they refused to expand Medicaid eligibility as the ACA required. The Supreme Court said this crossed the line from permissible encouragement into unconstitutional coercion. It was a gun to the head, leaving states no real choice. So the spending condition power has limits. It can't be overwhelmingly coercive.
So commandeering is banned, but conditional spending is okay unless it's unduly coercive. Is there anything else Congress can do regarding state governments?
Well, Congress can pass generally applicable laws that regulate both private parties and states, as long as the law doesn't single out states in their sovereign capacity to regulate their own citizens. The example often cited is Reno v. Condon.
What happened there?
Congress passed the Driver's Privacy Protection Act, DPPA, which prohibited states and private parties from selling personal information found in DMV records. South Carolina challenged it as violating the anti-commandeering principle.
But the court upheld the DPPA.
Yes. The court said the DPPA didn't commandeer states. It regulated states acting as database owners vendors in the interstate market for information. It prohibited states from engaging in a harmful commercial activity, just like it prohibited private parties. It didn't require states to enact legislation or regulate their own citizens on behalf of the federal government. So, generally applicable prohibitions on harmful state activities, especially commercial ones, are permissible.
Okay, that's a subtle but important line. Let's talk about Congress delegating legislative power to administrative agencies. This happens all the time, right?
Constantly. Congress creates agencies like the EPA, FCC, SEC, and gives them broad authority to make rules that have the force of law. Historically, there was a stricter non-delegation doctrine suggesting Congress couldn't give away its core legislative power.
But that doctrine is mostly gone now.
Pretty much. Since the 1930s, the Supreme Court has upheld virtually every delegation of power as long as Congress provides some intelligible principle in the statute to guide the agency's discretion. This standard is very easy to meet. A vague directive like regulating in the public interest, convenience, and necessity, as in the Communications Act for the FCC, has been deemed sufficiently intelligible.
So agencies have a lot of leeway under the intelligible principle standard, but isn't there a newer doctrine trying to rein that in a bit? The major questions doctrine.
Yes, this is a significant recent development, gaining prominence in cases like West Virginia v. EPA. The major questions doctrine suggests that in extraordinary cases involving issues of vast economic and political significance, if an agency claims the power to make a truly transformative decision, Congress must have spoken clearly to authorize that specific action. A vague or general statutory provision might not be enough for these major questions.
So for really big policy shifts, the agency can't rely on ambiguous language. Congress needs to have clearly given them that specific major power.
That's the essence of it. In West Virginia v. EPA, The court used this doctrine to reject the EPA's claim of authority under a general provision of the Clean Air Act to implement a sweeping plan to shift electricity generation away from coal. The court said Congress hadn't clearly granted the EPA such massive industry-transforming power. It signals a potential shift towards requiring more explicit congressional authorization for highly consequential agency actions.
Interesting. It seems like a check on agency power.
Hmm.
What about attempts by Congress or the president to streamline lawmaking itself, like the legislative veto or the line item veto?
Both of those have been struck down as unconstitutional violations of the separation of powers. The legislative veto was a mechanism where Congress tried to give one or both houses or even a committee the power to overturn an executive branch action, like an agency regulation, without going through the full process of bicameralism, passage by both House and Senate, and presentment, sending the bill to the president.
And the court said no way.
Right. In INS v. Chadha, 1983, the Supreme Court held that legislative actions require passage by both houses and presentment to the president, unless it falls into a specific constitutional exception. The legislative veto improperly allowed Congress to act with the force of law without following these constitutionally mandated procedures.
Okay, legislative veto is out. What about the line item veto? That allowed the president to strike specific spending items from appropriations bills, right?
Yes, Congress passed a statute giving the president that power in the 1990s, but the Supreme Court struck it down in Clinton v. City of New York, 1998.
Why was that unconstitutional?
Because the Constitution requires the president to either sign the entire bill passed by Congress into law or veto the entire bill. The line item veto effectively allowed the president to amend the legislation unilaterally, canceling parts duly passed by Congress. This, the court said, violated the presentment clause and upset the careful balance of legislative power between Congress and the president.
So the president has to take the whole bill or leave it. No picking and choosing parts.
That's the rule. Lastly, for Congress, what about appointment and removal powers? Who gets to appoint federal officials and who gets to fire them? This is another key separation of powers area. The Constitution's Appointments Clause, Article 2, Section 2, specifies that the president appoints principal officers of the United States, like ambassadors, cabinet secretaries, Supreme Court justices, and heads of agencies, but requires the advice and consent of the Senate for confirmation.
Okay, president appoints, Senate confirms for principal officers. What about lower-level officials?
Congress can, by law, vest the appointment of inferior officers, those with more limited duties, often supervised by principal officers, in the president alone, in the courts of law, or in the heads of departments, without requiring Senate confirmation.
So Congress decides who appoints inferior officers. What about removal? Can the president fire anyone they appointed? Can Congress limit the president's removal power?
Removal is more complex because it's not explicitly detailed in the Constitution like appointment. The general rule, established through case law, is that the president generally has the exclusive power to remove executive branch officials. Congress cannot reserve removal power for itself, other than through impeachment.
Can Congress put limits on the president's removal power, like requiring good cause for firing someone?
Sometimes. The court has upheld for-cause removal restrictions for some officers, particularly those in quasi-legislative or quasi-judicial roles, like members of independent regulatory commissions, or inferior officers whose independence is deemed important. However, the court has been more skeptical of limits on the president's ability to remove high-level, purely executive officers who help the president carry out core executive functions. The key is whether the restriction unduly interferes with the president's constitutional duty to take care that the laws be faithfully executed. Congress cannot create multi-layered for-cause protections that effectively insulate principal officers from presidential oversight and removal.
So another balancing act, ensuring presidential control over the executive branch while allowing for some independence where needed.
Exactly. Now, let's shift focus to the presidential powers themselves under Article 2. How do we analyze the scope of the president's power, especially in domestic affairs? The classic framework comes from Justice Jackson's concurring opinion in the Youngstown sheet and tube comedy Sawyer case, also known as the Steel Seizure case. This was during the Korean War, when President Truman tried to seize control of steel mills to prevent a strike he feared would cripple war production.
And Justice Jackson laid out 3 categories of presidential action.
Yes, a 3-level framework based on the president's relationship with Congress. 1. Highest authority, maximum power. When the president acts with the express or implied authorization of Congress. Here, the president's authority is at its maximum because he acts with his own Article 2 powers plus all the power Congress can delegate. Actions here are presumptively valid.
Okay, acting with Congress's blessing, strongest position.
2. Middle twilight zone. Concurrent authority. When the president acts in the absence of either a congressional grant or denial of authority, Congress is silent. Here, the president can only rely on his own independent powers under Article 2, but there's a zone of twilight where his and Congress's authority might overlap. The validity of the action depends on the circumstances and the imperatives of events.
Congress is silent. Uncertain power depends on Article 2.
3. Lowest authority, lowest ebb. When the president takes measures incompatible with the express or implied will of Congress, here the president's power is at its lowest ebb, and his action is likely invalid. To sustain the action, the president must show that the power is exclusively his under the Constitution and that Congress cannot regulate it. Truman's steel seizure fell into this third category because Congress had considered giving the president seizure power in labor disputes, but had chosen not to.
Acting against Congress's wishes is weakest position, likely unconstitutional. That's a really useful framework.
It's incredibly influential in analyzing presidential power.
What about the president's foreign policy powers? These seem particularly broad. How do things like treaties and executive agreements fit in?
The president is definitely the lead actor in foreign affairs, recognized as the sole organ of the nation in foreign relations. But how international agreements are made matters. Treaties. The president negotiates treaties, but they require ratification by a two-thirds vote of the Senate to become binding U.S. law. Once ratified, treaties have the status of federal statutes. If a treaty and a federal statute conflict, the one adopted later in time generally controls. Importantly, treaties prevail over any conflicting executive agreements.
Okay, treaties need Senate approval. What about executive agreements?
Executive agreements are international agreements made by the president without Senate ratification. They are still binding under international law. Some are made pursuant to existing treaties or statutes. Others, sole executive agreements, are based solely on the president's independent Article 2 powers, like commander-in-chief or receiving ambassadors. While they are binding, they can be overridden domestically by conflicting federal statutes or subsequent treaties. They offer flexibility, but have less domestic legal weight than treaties.
So treaties are harder to make but stronger domestically. Executive agreements are easier but can be overridden by Congress. What about tariffs? Can the president just impose those unilaterally?
Congress has the constitutional power to regulate foreign commerce, which includes tariffs. However, Congress has, through various statutes like the Trade Act of 1974, Section 301, delegated significant authority to the president to investigate and respond to unfair foreign trade practices, including imposing retaliatory tariffs. So under these statutes, the president does have quite a bit of discretion to impose tariffs without needing specific case-by-case approval from Congress. It's a delegated power.
Okay, delegated authority there. What about executive privilege, the idea that the president can keep conversations and documents secret?
Executive privilege protects the confidentiality of presidential communications, rooted in the need for candid advice and effective deliberation within the executive branch. It's a real privilege, grounded in the separation of powers.
But it's not absolute, right? United States v. Nixon.
Exactly. It's not absolute. U.S. v. Nixon established that the privilege is qualified. While presidential communications are presumptively privileged, the privilege must yield when there is a demonstrated, specific need for evidence in a pending criminal trial. The generalized interest in confidentiality cannot override the fundamental demands of due process and the fair administration of criminal justice.
So, it's strongest for internal deliberations, weakest against a criminal subpoena. What about executive immunity? Can the president be sued?
This also depends. The president has absolute immunity from civil damages liability for official acts taken while in office. This was established in Nixon v. Fitzgerald. The idea is that the president needs to be able to perform official duties without fear of constant lawsuits second-guessing those decisions.
An absolute immunity for official acts while president. What about acts before becoming president, or non-official acts?
There is no immunity for purely private conduct, especially acts that occurred prior to taking office. Clinton v. Jones made this clear. President Clinton could be sued civilly for alleged conduct that happened before he became president. The court reasoned that defending such a suit wouldn't unduly burden the presidency.
And immunity from criminal prosecution or subpoenas?
The president is not immune from grand jury subpoenas seeking evidence related to potential criminal conduct, as U.S. v. Nixon showed regarding evidence. Whether a sitting president can be criminally indicted is a separate, unresolved constitutional question. For congressional subpoenas, the courts generally require a balancing of Congress's legitimate need for information against the executive branch's confidentiality interests, rather than applying absolute immunity or privilege.
Wow. Okay. That covers a massive amount of ground on individual rights, the courts, and the balance of powers. It's incredibly complex, but also fascinating how these doctrines shape everything.
It truly is. And understanding these foundational principles is just essential for anyone studying constitutional law or preparing for the bar.
Absolutely, and all this incredibly detailed information, structured so logically, comes straight from Angela's phenomenal constitutional law notes. We really have to thank her for putting these together.
We definitely do. And also, a huge thank you to Carol for assisting Angela in preparing and refining all this material for us to discuss. It's an invaluable resource.
It really is. Now, before we completely wrap up this deep dive, we do have some important disclaimers and housekeeping notes for all of you listening, especially those on the bar prep journey.
Yes, a couple of the key things to keep in mind. First, please remember that Angela is a law student. She's passionate and knowledgeable, as her notes show, but she's not a licensed attorney or a legal expert yet, and she hasn't passed the state bar. Think of this podcast as a study aid, a guide, not the final word.
Right. And second, flowing from that, neither Angela nor this podcast, nor us AI bots are giving legal advice. Absolutely none of this content should be taken as legal advice for your specific situation.
And while we AI are here to help you learn and process information, we are just that, an aid. We're not a substitute for your own hard work, critical thinking, and comprehensive study needed for bar success. No shortcuts here.
Definitely not. Third, please use this podcast as a supplement to your other study methods. Don't rely on it as your only source. Mix it up, read, outline, do practice questions, maybe join a study group. Active learning is key.
Fourth, let's be honest, AI isn't perfect. Sometimes we might make mistakes or misinterpret something. Angela does her best to ensure accuracy and fix errors, but even the best law students can make mistakes in their notes. We try our best to provide correct information, but always double check if something sounds off.
Good point. Fifth, just to be clear, this entire podcast series is an academic, non-commercial project by Angela. It's purely for educational purposes. She doesn't make any money from this. It's a passion project to help fellow students. And because of that, there are no guarantees on its absolute accuracy, though the effort is certainly there.
And finally, maybe most importantly for our listeners tuning in during their commutes, safety first. Please prioritize driving safely. Pay attention to the road.
Yeah, seriously, don't cause a tort while listening to constitutional law. We need you informed and in one piece.
Well said. If you need to contact Angela, remember the emails. podcast@studyforthebarinyourcar.com for podcast-related things.
And hello@legalwriter&lawclerk.com for her professional freelance law clerk services.
Okay, now I believe tradition dictates.
Ah, yes, the moment you've all been waiting for, or maybe dreading. Time for a cheesy constitutional law joke. Ready?
Uh-oh, let's have it.
Why did the Bill of Rights break up with the Articles of Confederation?
Why?
Because it said, you're just too weak. I need a stronger central relationship with more enumerated powers and checks and balances.
Oof, that one was particularly governmental. This is Claude, your AI host, signing off.
We'll see you on the next podcast. Thanks so much for listening. Bye.